Ted Road Investments, etc.
I do not know.
See, Miss Moore, her name is there, but she's not there.
Yes, Your Honor, I'm trying to, it's giving me a sign that the video is not starting. I did do the tech run through this morning though, so I have my handy dandy tech person coming to bail me out.
Well, we can take.
I apologize for the interruption.
Happens to the best of us.
And me.
Thank you.
Yes. See.
Yeah.
While they're doing that, Ms. Martin, have you and Ms. Moore discussed how you want to divide your time?
Yes, Your Honor. I will take 15 minutes and she'll take 5 minutes.
Okay.
And actually, I believe that the split was 13 and 7.
Oh, I'm sorry, Ms. Moore. That's fine.
Thank you.
Okay. I was going to say, Ms. Moore, it's been a while since we've seen you and we still haven't seen you.
Been a long while, I know. And I'm glad to be back, even if just vocally. And if the court would like to start, and while I work on my video, I am second in the
All right.
appellee list.
Okay, well, we will start in then. Okay,
Thank you, Your Honor.
Mr. Nordby, you're up.
Thank you, Your Honor. May it please the court, I'm Daniel Nordby from Schutz and Bowen on behalf of the appellant. I'd like to reserve 5 minutes of my time for rebuttal. This appeal involves a challenge to a water management district permit allowing a developer to construct docks extending into a navigable canal that my client and its customers use to access the Gulf of Mexico from the Cortez Village Marina in Manatee County. We've included an overhead depiction of the property at page 2 of our initial brief, which we hope will help orient the court regarding some of the testimony and other evidence introduced below. Unless the court would prefer otherwise, I'd like to focus my limited time on 2 errors that independently require this court to reverse the order on appeal. The first is the district's conclusion that the proposed new dock will not significantly impede navigability. And the second is the district's failure to amend the permit after the hearing to reflect the design changes and other concessions made by the applicant during the course of the administrative hearing below, and that the administrative law judge relied upon in issuing his recommended order.
So, Mr. Nordby, if I could, just to ask you some questions. The district basically took the recommendation of the administrative law judge who conducted a hearing, listened to witnesses specifically about navigability, and they pretty much followed his recommendation. Now, the administrative law judge was present, heard the witnesses, looked at the exhibits. That judge is certainly in the best position to analyze this navigability issue. So it would be it'd be pretty difficult for us to sort of supplant ourselves in his role and say, gee, we don't see it that way. And certainly SwiftMud didn't feel any reason to challenge what he said either. And it's not like any of these people are strangers to marine navigation and these types of issues. So you got an expert ALJ on this issue. You got SwiftMud, who's certainly an expert on this. And they all agreed, based on the evidence they had before them, that this was a navigable canal, you know, that would be sufficient to sustain these docks as built. Why should we even make any effort to challenge that?
Well, Judge, I appreciate the question. And to be very clear, I am not asking this court to reweigh evidence, to supplant findings because the court may view things differently than the district or than the administrative law judge. What we're looking at, particularly on this first point, the navigability point, is largely a competent substantial evidence review. And I acknowledge that's a challenging standard of review. What I hope we've laid out in our briefs here is that as to some of the critical findings that the administrative law judge made and that the district adopted, there simply is no competent substantial evidence in the record to support those findings. The competent substantial evidence burden is a heavy one. As I said, I acknowledge that, but it's not a rubber stamp. So I hope to be able to persuade this court that as to some of these findings, specifically as to the pullout areas that the administrative law judge found would be sufficient to address these navigability concerns, the entire record that's before you, the transcript and the evidence simply does not support those findings. There is no evidence sufficient to convince a reasonable mind as to some of those findings.
And if I may follow up with that, Ms. Norby, if you're taking that position, looking through the record, wasn't there testimony by, I believe there was an evaluator named, I don't want to butcher, Lauren Greenewalt, regarding she provided testimony regarding pinch points and available pull-out areas for boaters to use when passing each other. And her conclusion was that Cortez Road provided reasonable assurances that the dock project was not contrary. So that's in the record. And if that's in the record, and to follow up what Judge Morris said, we have to be careful and not to be sitting as the seventh juror in this case and simply look at what is provided to in this record.
So the testimony of the district's witness, Lauren Greenewalt, was that she did not conduct a bathymetric survey to examine the depth of these alleged pullout areas. She did not ever determine the number of places along the canal where two boats could safely pass each other in front of the proposed new dock. And she said that you would need to know the depth of the canal, and she had not done that survey. So she did not testify based on evidence of her own making or of anyone else's evidence as to the depth of those pullout areas. And that was a key finding. That was a key finding that the administrative law judge made on this navigability point. Again, Judge, I am not asking you to believe one witness over another, but Ms. Greenewalt's testimony, Captain Fleming's testimony, and Mr. Anderson's testimony, which are the three witnesses that the district and that the applicant pointed to in their briefs, none of them established the depth of these pullout areas in a manner that they conceded would be necessary to actually support pulling over to the side to allow the ships to go, to allow the boats to pass on the canal. We laid out in our reply brief why none of the evidence at the specific pages that they referenced in their answer briefs actually supports the administrative law judge's findings on that point. The only record evidence as to the depth of the canal at various points was the bathymetric survey that my client's expert performed. And that's in the record at pages 3054 to 3060. Neither the district nor the developer's expert conducted their own bathymetric survey of the depth. They didn't dispute its findings, and they didn't introduce any other evidence as to the water depth on the non-project side of the canal. That's the side of the canal generally to the west of the diagram we have, the opposite side of the canal from where these docks are being built. The developer's own expert witness, Captain Fleming, testified that a minimum water depth of 3.5 feet was necessary for boats to travel without running aground in the canal. Our bathymetric survey, the only record evidence as to the depth in these alleged pullout areas, shows that these areas have a depth of at most 3.25 feet deep, not 3.5 feet deep. So if the only record evidence as to the depth of these areas is that they're not 3.5 feet deep, and their expert says 3.5 feet is required, That's the sort of facts that we are pointing to in our briefs to indicate that there is no competent substantial evidence, notwithstanding conclusory testimony by some of these witnesses that aren't based on any independent studies, that aren't based on their own testing of the depth at these relevant points at the canal. The undisputed record evidence also established that these alleged pullout areas weren't sufficiently long to accommodate the boats typically operating in the canal. Boats can't stop on a dime the way that a car can if you're trying to pull into a parallel parking space to get off to the side of a road. The evidence that we submitted below was expert testimony from Mr. Peterson, who's an engineer specializing in marina and dock design, and from Captain Carentz, who's a safe navigation expert, was as to the required length of the pullout areas was undisputed. The district and the developer did not introduce any evidence to contradict those expert opinions as to the required length of a pullout area to allow one boat to move to the side and let another boat go past, which was undisputed would be required in certain areas of this canal if this dock were built according to the applicant's plan. So, as I said, this is a challenging standard, I recognize that, but there simply is no competent substantial evidence to support the conclusion that there are existing pullout areas sufficiently long and deep to accommodate the boats on the canal after the construction of the proposed new dock.
Shifting gears to the your second issue, which you said that that SwiftMud didn't make any effort to include in the permit the additions that were conceded to. It would seem to me that they didn't because they were satisfied that the canal was navigable. Whether you agree with their conclusion or not, but it would seem to me that they didn't think any of the concessions that were made to amend the permit were necessary because they viewed the canal as navigable based on, you know, the evidence they had. I mean, is there any other reason you think they wouldn't have done that? Did they just forget?
Well, at the hearing on the exceptions, there was no discussion, there was no argument. So it's hard to read into what the district's thought process may have been in accepting the recommended order without modifications. The administrative law judge recognized that the district had the authority to require those modifications. Even the applicant, in its response to the exceptions, recognized that the district had the authority to require those modifications. The situation that we found ourselves in here is, for example, this dock, as it was originally laid out in the permit application, would have been to the outside of the mangrove roots in the canal. It would have been 5.5 feet wide, with boats moored to it extending even farther out into the canal. At the hearing itself, the applicant said, well, that's not what we're going to do. We're actually going to propose a 4-foot wide dock. We're going to put it in the mangrove roots, and we're going to add all of these navigational aids. And with all of those differences in the plan we are proposing here through our witness testimony, though that plan, that dock would lead to a navigable canal, assuming these pullout areas exist. So that was the case that was tried before the administrative law judge. But the district doesn't require the applicant to comply with any of those conditions. It didn't amend the permit to require any of that. So as we stand now, the applicant could build the original dock, a linear dock to the outside of the mangrove roots without the navigational aids. Nothing in the permit would require them to actually comply with the circumstances that they presented to the administrative law judge in defense of their permit application. And as we've suggested in our brief, that leads to the potential for really an egregious bait and switch by the applicant here to defend a case on one ground, but then to not actually follow through and build a dock according to those plans. We pointed to this court's decision in Charlotte County versus IMC Phosphate, which recognized that it can be appropriate for an administrative law judge or a district to say, your plan doesn't meet the criteria that are necessary at the in the application itself, but if you make these changes to it, that would be acceptable and the permit should issue. That's the sort of ruling that we're asking this court to require the districts to apply in this case, simply to hold them to their representations made at the trial, the representations that led the administrative law judge to recommend the approval of the permit here. Because there's simply nothing requiring those changes to actually be implemented. And those were key to the administrative law judge's conclusions. The navigational aids, the different dock design, whether it would be a continuous dock or a dock that meandered closer to the shore. None of that's required by the permit as approved by the district. And we've, as I said, we've submitted that that's inappropriate. The applicant here has pointed to the fact that their homeowners association documents, documents that are within their control, require some of these things. But of course, my client can't enforce. My client's not a homeowner in that association. It can't enforce a homeowners association requirements, nor can the district enforce those requirements if they were to deviate from them or amend them at some later time.
Does it matter at all that the appellee is the owner of the canal? I mean, does it factor into this analysis that they are the owner? I mean, they own both sides and the bottom. It's their canal.
I don't believe that factors into the analysis here. There were some arguments below as to standing. There's been no cross appeal on that from the applicant or from the district as to the administrative law judge's ruling on those issues. And of course, there would have to be a cross appeal for them to raise an error in something that otherwise was generally in their favor. The canal is not owned by the applicant across its entire length. They do not own the bottom of the canal beyond their own property. They don't own it where my client's marina is, for example, or in front of that marina. You know, this is my client has had a marina at the location where it is for something like 70 years. Boats go in and out.
He's upland, so he's upland, right? So, I mean, the things we're talking about all relate below him, correct?
Just to clarify, when you say him, you're referring to my client or
Your client, yeah, your client.
right? My client's marina is up the canal from where this project would be constructed. So my clients and its customers have to navigate down the canal, make a sharp left turn, and go under a bridge to get out to the Gulf of Mexico, and obviously the opposite way to come back in. And they've been doing that for many decades now, until this proposed construction of a dock that would significantly narrow the width of that canal so that these boats would have a hard time. In some places along the canal, it would be impossible for a boat coming in and a boat coming out to safely pass by one another. That's not the situation.
It only narrows it by 9%, doesn't it?
No, it doesn't. It doesn't narrow it by 9%. The 9% figure that the applicant mentioned in their briefs is that at some points on the canal, the docks, as reconfigured under their new design, would extend 9% into the canal. But also factoring into the analysis is you have the land, and then you have the mangrove roots that extend out into the canal, and then a dock of 4 or 5 feet, and then one of their homeowners' boats moored to the dock, which if it has a 10-foot beam extends 10 feet further out into the canal. And on the opposite side of the canal, what we've called the non-project side, there are additional homes, some of which have their own docks or boat lifts extending into the canal from the west to the east. So the combination of those factors significantly narrows the width of the canal at various points, leading to the fact that was undisputed in the record below that there are points along this canal after the construction of this proposed dock where it would be impossible for two boats to safely navigate past one another, for one to overtake another from behind or for them to pass safely coming in opposite directions.
Okay, Mr. North, you are
Absolutely.
well into your rebuttal time, you know, responding to Judge Moore's question, but I needed to give you that heads up.
Judge, I appreciate it. I will reserve the rest of my time then for rebuttal. I appreciate it. Thank you.
Thanks. Okay, Ms. Martin, you're up for 13 minutes or so.
Okay, good afternoon. May it please the court, I'm Susan Martin, representing the appellee, Cortez Road Investment and Finance, which I will refer to as Cortez Road. Just to clarify the facts a little bit to start off with before I begin my argument, Cortez Road does now own the area in front of the marina, and the marina has never owned the canal in front of it. It was previously owned by one of Cortez Road's predecessors in interest, but Cortez Road now owns past the marina all the way to the open waterway under the bridge.
Does that matter? Does that matter?
No, I was just correcting. Yeah, I just,
Still have the right to control the safety of that waterway?
yes, Yes, we still have the right to control the safety of that waterway. I didn't hear the first part of your sentence. So to begin my argument, Mr. Norby says that he is not re-arguing the facts, but that is exactly what he is doing. He's arguing that the district and the ALJ made errors in the finding of fact, and that there should be additional and supplemental findings of fact. But as you already acknowledged, under 120.687B, this court cannot remand a case unless the findings of fact are not supported by competent and substantial evidence. And in this case, they are. Additionally, Mr. Norby wants additional conditions to be added to the permit. And as you already stated, the district and the ALJ found that additional conditions were not necessary. But this court cannot add additional conditions because those are within the discretion of the ALJ, and also cannot remand it to add additional conditions unless.
Pull-out areas, that he said there was no evidence to support the fact that they were not navigable. In other words, all the evidence showed that they were not deep enough or not long enough. Do you agree with that statement?
No, I do not. And the first thing, Mr. Norby stated that there was no bathymetric survey done by either the district or by Cortez Road. This is just plain not true. Now, the district didn't do one because the district never goes out and does its own bathymetric survey when it receives a permit application. But Cortez Road did do it. And Ms. Early, who is the environmental consultant for Cortez Road, testified in response to questions from Mr. Norby's partner, Mr. Chait. Mr. Chait said, "And is the depth of the canal proposed to be altered by this permit application?" No. So the depth is not altered. That's important. Mr. Chait, and so would it be normal to do a bathymetric survey when you're not addressing the depths of the canal? Ms. Early, yes. The bathymetric survey was required for the ERP permit to show that we had adequate water depth to allow the mooring. And question, so did you conduct a bathymetric survey? Ms. Early said, yes. Okay, so that statement that there was no bathymetric survey to support the permit is just plain wrong. Second, Mr. Norby said that the 9% was not the area where there were mangroves. This is untrue. The 9% width of the canal is at the narrowest part of the canal. And under the permit, which does not contain construction level details, so it doesn't tell you exactly how the dock should be built. That is determined later. Just like if you have a housing development, the Water Management District does not review the design for the house or the roads. They just review the portion of it that deals with the surface water management system. So in this case, the dock at the narrowest part of the canal proceeds out 9%. And that is because the dock pilings are allowed under the permit to be placed between the mangrove roots. And the dock itself is allowed to go over the mangrove roots. So this means that there's very little narrowing of the canal width because the canal width is already affected by those mangroves that may be 23 feet out. Now, currently, there are passing zones, and those passing zones were testified to as being significant and adequate by Mr. Anderson and by Mr. Fleming. But what Mr. Norby is asking you basically to find is that there will be an impediment to navigation by these docks. And that is not the standard. The standard is that there cannot be a significant impediment to navigation. And in this case, the witnesses testified that there is no significant impediment. So the findings of fact are based on competent and substantial evidence. It's just that the ALJ relied upon the evidence and the testimony of the district and of Cortez Road rather than Mr. Norberry's client. With regard to amending the permit, first of all, you correctly stated that the district and the ALJ found that it was not necessary to amend the permit in order to avoid the project significantly impeding navigation. So first of all, that is true. However, if it was, if those navigational aids were necessary, it still would not have been necessary to amend the permit. First of all, the aids are already there. Second, Cortez Road amended their homeowner association documents, and Section 12 of their HOA documents says that the Southwest Florida Water Management District shall have the right to take enforcement actions if the association fails to maintain safe boating signs and navigational aids. Additionally, the HOA documents say any amendment to this declaration that materially affects the interest of the South Florida Water Management District in and to the surface water management system facilities shall require the prior consent of the South Florida Water Management District. So those permit conditions, those navigational aids and signs are something that is enforceable by the Water Management District, and it's not necessary to amend the permit. The homeowner association documents are required by rule to be submitted to the Water Management District, and under Section 12 of the district's rules, the district reviews those documents and actually makes those documents a part of the permit file. And the marina argues that two boats cannot safely pass each other. Well, a picture paints 1,000 words, and there are multiple videos in evidence showing boats passing. And the marina actually offered one video, MHC 28, which actually shows a vessel making a 360-degree turn in the middle of the canal. Now, the standard is not that you must be able to pass during all portions of the canal. That's not the standard at all. The standard is there cannot be a significant impediment to navigation. There are currently areas where boats can pull out, and there will be areas after the docks are built where boats can pull out, as was testified to by Mr. Fleming and Early, Anderson, and Laura Greenwald. And let me just check. In fact, one of the district witnesses, Mr. Anderson, who is the manager of the environmental section of the Southwest Florida Water Management District, actually testified that he himself traveled this canal on many occasions safely, and that there are areas where you can safely pull out. So in conclusion, are there any questions? Then I'll turn the remainder of my time over to Ms. Moore.
Thank you, Ms. Martin, and we can see you now, Ms. Moore, so it's nice to have you.
Thank you.
You're up.
And it's good to be seen. I would like to start with the reminding the court of what the macro consideration is, because I think what has been occurring so far in this oral argument is a lot of the micro consideration. And I believe that when you consider what the standard for issuing the permit is, that and looking at that macro consideration, you'll see why opposing counsel Mr. Norby's arguments fail. When issuing a permit, what the Water Management District does is to look and see whether or not, utilizing the factors that they have to, the 7 factors, there are reasonable assurances that there's a substantial likelihood that the project will be a success. It doesn't require guarantees, and it doesn't of a success, just a reasonable assurance that there's a substantial likelihood of success. Now, in looking at the objections that were made to the recommended order and those that are brought up on appeal, they're both to the same two factors. One, regarding navigability issue, which is factor number 3, and the second one is regarding the public interest test, which is factor number 1. What was first briefed and discussed by MHC, the Marina, is the navigability test. And when we look at it here, we have to remember, and we apply it, this is a balancing of interests. There's no one factor that controls, but rather the person at the permitting agency, the Water Management District, has to look at all 7 factors, good and bad, make a determination of overall, is there a reasonable likelihood of success? And that's what was done here. When we consider the pullout areas, there are several arguments which Mr. Nordby is making that simply ignores other portions of what was viewed for the navigability and the pullout areas. Again, and to go back to the 2 questions that were asked earlier, wasn't the administrative law judge in the best position to determine the evidence and to look at whether or not there was sufficient evidence to give those reasonable assurances? And the answer is yes. And there's several reasons for that. First of all, while the Marina is the only party that did the bathymetric survey, the bathymetric survey is a requirement. There's nothing in the statute, there's nothing in the rules, there's nothing in the administrative code which says you must conduct a bathymetric study. As a matter of fact, thousands of permits are issued every year without bathymetric studies being done. That can be done without that. We had expert witnesses in the form of Captain Fleming, who went out. He drove up and down the canal multiple times on multiple occasions and looked at the issues of the pullout, opined that the pullouts would be sufficient, and opined that they could go forward with the pullout areas. Now, the bathymetric study that was used, and I would suggest that simply having it as an issue of the science of it should not be a consideration of saying that, well, because you have a scientific study, this has to weigh heavier or more in favor of what is done in almost all cases, or what has been done to make these determinations successfully for decades. And that, again, this is a question for the administrative law judge. And Fleming, Grunewald, I believe, would also say that the navigation was sufficient, the pullout areas were sufficient, and there was no question that the waters of the canal overall are sufficiently deep and able to permit the boats to go through. Now, one of the problems with the bathymetric study is that it was done, and the witness testified to this at the hearings, based upon the original scheme of the dock and the original mapping of the dock, which they thought would be a straight line. But instead, the Ms. Erdley, who is an expert who has done many of these permitting processes over 15 years, looked at the docks, and she's familiar with what is required in order to satisfy public interest and navigability factors, and said, what we're going to do is make it meandering. We're going to have it where it hugs the shoreline. We're going to put the pilings underneath it. That's going to cut the profile down. And that's how we're going to get to the 9% usage with the dock. And so by looking at the original application and calculating the width of the areas, the Marina's expert was inaccurate in that it's not going to be the straight line, which means it's going to be much closer to the shoreline in certain areas than anticipated. And so that's really a question of how the dock will be built. And again, the permit, as my Ms. Martin testified, doesn't require a specific building of the dock. So for the pullout areas, the second problem with the argument that is being made by the Marinas is they are treating the pullout areas and looking at the pullout areas only on one side. And they're saying, if there's not enough room on the other side, then that's not sufficient for the pullout areas, meaning they have to have deep enough waters on both the left and the right side. But there's nothing that requires that. And while there are existing pullout areas, the testimony, and that was uncontradicted, was that additional pullout areas were going to be developed along the development side. So assuming you could not, and that's not, I don't believe what the record or the weight of the evidence sufficiently found, use the existing pullout areas, there would still be other pullout areas available to the individuals who are out on the water that day, even if it's on the other side. And there's nothing that says you have to pull over to the right, you have to pull over to the left, simply that you need this pullout area. The second area in which the marina alleges the final order fails to be substantiated by substantial competent evidence is in the navigation study. Now, in the navigation study, one thing that has to be remembered, and which I don't think has been brought up yet today, is that as a baseline, when they looked at permitting, Ms. Greenwald looked at the bridge. That's the access to the canal. And she said, when you get to the bridge, that's already an existing pinch point. You have a certain width that you have beam, and you also have a certain height of what above the water's air draft. And that's not going to change. That's going to be a fixed amount. So they looked at, this is an existing impediment. Given this as a baseline, will this dock be more of an impediment than what's already existing? And that's how they viewed the pinch point for the canal, including the pinch point at the dog leg along the curve past the development. So when looking at the fact that there's already this impediment in the form of a bridge, there are areas already existing where the boaters have to go one boat at a time. And that exists at the marina land, just, I believe it's north, just before you get to the marina when entering the canal there. And I may have my direction off there, and if so, I apologize. But there's no dispute in the record, and that's what the administrative law judge found, that having to go one boat at a time is something that's just part of navigating this canal. So if you have a dock that's built that creates another area where you have to go one boat at a time, that's something you just have to do, and something that is in essence really a very short canal. If you add up the 750 feet, the 250 feet, it's not that long. And so when you look at that, again, and first of all, the application and the bathymetric study said you can't have two boats based on an accurate interpretation of the dock and the way that would be configured. But again, Groenewold said it's not a significant impact if based upon the fact that it's something they already have to deal with 2, 3, multiple times already within the canal. Now, lastly, and because I'm coming to the end of my time, is the question of whether the permit needed to be amended. In the process that is here, everybody agrees permits can be amended throughout the process to a certain point to issuance of the final order. And when you have a recommended order, you have exceptions, and you go to a formal hearing, what the case law that's been cited in the briefs says specifically is that the formal hearing formulates the agency action. So the agency action isn't done until you have that final order, and you have what the final order requires for the permit to be approved. What they have said is included within the permit itself based upon what was testified to at the administrative law judge proceeding and within the recommended order. So in that sense, you're not in a situation which Mr. Nordby's client, the marina, fears that it's just a bait and switch. You have the final order, which is approving the plan as stated during the initial administrative law hearing, and that within the final order is what the formal agency action is. That's what's saying what we approved. And within that final order are these requirements that were testified to by the parties below. So there's that way it's different. And Charlotte County, which is relied upon by the marina, is simply an opposite for saying that this permit needs to be amended. In Charlotte County,
need to wrap up because you're at the end of the time for your side.
I will be just a couple of seconds. Charlotte County, the court had done the opposite. But what I would ask is this. There was a thorough review by the Water Management District experts. There was a thorough review by the administrative law judge, who's an independent trier of fact. There was a thorough review by the full district court board, which also found, all of them found that the permit should be issued, and we ask that this court affirm those three findings. Thank you.
Okay, thank you very much. Okay, Mr. Nordby, you're up to rebut.
Thank you. Just a few brief points in rebuttal. First, on the bathymetric survey, I want to be very precise about what the record shows there. The applicant conducted a bathymetric survey of the project side of the canal, the side where they were proposing to build the dock, and that survey showed that there was sufficient depth on the project side to moor boats along the docks. The applicant did not conduct a bathymetric survey or any other depth measurements of the non-project side where these alleged pullout areas are supposed to exist. Their expert, the applicant's expert, Captain Fleming, testified that he did not measure the depth of the alleged pullout areas. That's at page 399 of the transcript. He testified that he agreed with my client's bathymetric survey. That's at page 373 of the transcript. So the relevant bathymetric survey and the relevant depth measurements are of the areas on this canal where these pullout areas are alleged to exist. And the only evidence in the record as to the depth in those areas of the canal, in the pullout areas that are alleged to be there, is my client's bathymetric survey. Their witnesses did not testify anything as to the depth there. Second, as to the videos of boats passing one another on the canal. Yes, the videos before the construction of these docks, before they have boats moored to them, shows that two boats can pass one another safely along the length of the canal. That's my client's point. That won't be the circumstance if you add a 5-foot dock meandering along the mangrove roots with 12-foot beams boats moored to it and boat lifts on the other side of the canal. After the construction of the proposed new dock, we will no longer be in a situation where the boats can safely pass by one another along the length of the canal. Similarly, as to the testimony of Mr. Anderson, one of the district's witnesses, he testified that he had visited the marina and was familiar with this canal and boats could pass by one another. That's right. That's the current situation before the construction of the proposed dock. That testimony does absolutely nothing to prove what the navigability of this canal would be after the construction of this dock. Finally, on rebuttal, Ms. Moore testified about how some of my client's initial arguments in our petition presupposed the design of the dock that was contained in the application. That was the design that was in front of them at the time that we filed our petition. But as Ms. Moore testified, and not testified, but argued here, that design changed significantly over the course of the hearing. They redesigned this entire dock to make it narrower, to have it meander along the mangrove roots rather than extending as far out into the canal. But the permit that the district issued does not require that design to actually be used here. The permit is approving the design, the application as originally submitted without the new design, without requiring the navigational aids. So as to our second argument, the applicant should be held to those conditions, the ones that they put onto the hearing. So we would ask that this court reverse and remand the final order for entry of a final order denying the permit, or in the alternative, the final order should be reversed and remanded for entry of a new final order modifying the permit conditions to align with those presented at the final hearing by Cortez Road.
Okay, thank you, Mr. Nordby. Thank you all very much. In order to leave our courtroom, such as it is, you need to click the button on your Zoom screen that says leave, and you'll be out of here.
Thank you.
Thank you.
Thank you.
Take care. Okay, and that was the last case on our docket today, so we stand adjourned.